All right, guys. So this is Neil deGrasse Tyson talking about the criminal justice system.
The third time I was rejected from jury duty. The judge reads the particulars and said, does anyone think they would not be able to convict? Yes, I'd have a problem if the only evidence available is eyewitness testimony. Then everything I know about it tells me I should not trust it on the level where you end up putting someone in jail. What the judge said next was, are there any other jurors, like juror 14, who needs more than one witness before they would be able to convict? The person in front of me said, Your Honor, that's not what he said. I resisted with all my might to say, Your Honor, you were eyewitness to what I said 20 seconds ago and got it wrong.
Yes.
Hey guys, Seth Fuller, Texas trial champion. First, I want to thank you for making 3 million views on my Neil deGrasse Tyson video. Can't express how much appreciation I have for you for that. But I wanted to clarify a very important issue about that Neil deGrasse Tyson video. Now, a lot of y'all didn't believe Neil because you think he's a braggart or stupid or works for the government or something, apparently. But a lot of you had a real confusion that I want to straighten up for you today. And that is why the judge would be asking Neil something like, could you find beyond a reasonable doubt by just one witness? Some of you didn't believe any of that story, but let me tell you, that is something a prosecutor or a judge in certain cases might ask of a panel. And by panel, I mean a voir dire panel, the panel of jurors from which a juror of 6 or 12 people is selected. What I'm talking about is the one witness rule. So what is the one witness rule? The one witness rule is a rhetorical trick by prosecutors to keep juror members that might have too high a standard for beyond a reasonable doubt, which is the highest standard there is by law, off of their jury panel and onto the streets. One person who commented on my video said they were a prosecutor and they keep anyone with a science degree off of the panel, off of their jury, because that person is going to apply the requirements of science to beyond a reasonable doubt. Now, I believe that. And if you don't, just listen to what the one witness rule is. So basically, the state has to prove the case beyond a reasonable doubt. And that's the highest standard that is by law. That's a higher standard than to take away your kids and remove you as a parent for your kid. You don't even have any rights to your children at all. That standard is clear and convincing evidence, and beyond a reasonable doubt is supposed to be higher than that. And prosecutors don't like that. So they want to keep people with a really high standard off, and they want people with a really low standard on. And in my opinion, and just looking at all the Project Innocence, there's no doubt that the number one thing that gets innocent people convicted is not bad science, bad lawyers, bad prosecutors. It is bad jury members who don't keep a super high standard of beyond a reasonable doubt. Now, we can't define reasonable doubt in most states, especially here in Texas. We can't define reasonable doubt. So the standard I want my jury members to have is that if there exists a different world where a reasonable situation could happen that negates this defendant being guilty, then that is reasonable doubt. I'll give you an example. If there is a video that exists that could show my client didn't do it, if it could just exist, reasonably exist, then that means that there's a chance that you're sending an innocent person to jail if you find this defendant guilty. So if they haven't put together a case that completely precludes a video like that existing, reasonably existing, then you should find them not guilty. That's the standard that I use, but I can't even make a jury member promise to do that. They have to use their own standard. And so in comes the one witness rule, where the prosecutor asks, if I bring one witness and prove my case through that witness and that witness only, and they've convinced you beyond a reasonable doubt that the defendant is guilty, can you then find the defendant guilty? And so a lot of people who believe, like Neil deGrasse Tyson does, that eyewitness testimony is not very good, which is most people who've been paying attention, they immediately say, no, I couldn't do that. And then they get kicked off the jury panel and they're not a juror. The trick is in this first part, the first premise. If I could prove through one witness beyond a reasonable doubt every element of the case. And what Neil deGrasse Tyson was saying was not that if they could do that, can you convict? What he was saying is that he doesn't believe one witness could do that. And that in and of itself will not get you kicked off a panel for cause. They can use one of their preemptive strikes, which are very few, but they can't kick you off for cause. But they don't make you think about that. They ask you the trick question of, if I were to prove it beyond a reasonable doubt, would you then convict? And the correct answer is yes. Of course, if you prove it through the one witness beyond a reasonable doubt, you should convict. That's how the law says. But they don't really give you an out. They don't explain it in a way where you can go, I don't believe one witness could do it. And then they make you commit to that. So what I do as a defense attorney, and I do this successfully, is I wait until they finish and I get my turn. And then I give a scenario where one witness could convince someone beyond a reasonable doubt, because that does exist. If you think about most sex offenses or more serious offense that someone's trying to do, they're trying to have as few witnesses possible. So if it's a sex offense, usually they just want them and the victim there. And we can't let all sex offenses where they were successful at that go. And so I give them an example where they wouldn't let someone like that go. In this example, the person is a stranger. They have nothing against the person, but they notice something in the commission of the crime that can only be true and observed if it is the defendant. Let me give you an example. Someone is confused of purse snatching, grabbing a purse and running, and someone who doesn't know them at all, is from a different city, maybe a tourist or whatever, identifies the defendant as the person who snatched the purse. Then generally you don't know if they have the right identification, if someone planted something in their mind or anything like that. But let's say the prosecution convinces you that they're out of state, they have no reason to lie, they observe this, and that person comes in and testifies that while the person was running away from the cops, their pants leg came up and they were able to see that they had a prosthetic leg that had a certain crazy design on it that was custom to a prosthetic leg. And so the only way they would know that that the person who robbed them had the prosthetic leg that it turns out the defendant does own is by having witnessed that. Nobody told them about the prosthetic leg. The police didn't know about the prosthetic leg until they testified. So it's a perfect case. They've proven every case beyond a reasonable doubt that this defendant did it. In that case, of course, you would on that one witness say, yes, I'm going to convict on that witness. Or maybe you wouldn't, but regardless, if you found that they did prove the state proved every element through that one witness, the answer is yes, you would. If you wouldn't, it's what you're probably saying is not that I can't convict him guilty even though they've proven their case. It's that I cannot think that one witness and one witness alone is enough to get me beyond reasonable doubt. And if you say that in court, you'll be left on the jury and you'll be a great juror. But if you let them trick you, you'll be kicked off the jury and they'll get a bunch of people with a low standard, and an innocent person will eventually go to jail if you do that enough times. In fact, if you look at actual innocence cases like Project Innocence and all that, generally this is how people get wrongfully convicted. The jury lowers their standard of reasonable doubt and they leave open the possibility that someone's brother did it, that someone besides the husband did it, that there was a crazy serial killer coming through town and who killed somebody's wife or husband and then left, which is the case in Michael Morton, who is the namesake of the Michael Morton Act, which says the prosecutor has to turn every piece of evidence over the defense. Because Michael Morton was convicted of murdering his wife, he spent years and years in prison, and meanwhile the person who was coming through town who actually did kill his wife killed somebody else and was in prison for that. And then when it was discovered that that guy did it, because he admitted in jail, it turns out the prosecutor didn't tell nobody that they might have known that this guy was in town and this guy was around and that this guy might have told people he did it. And they didn't reveal that. And instead, this Michael Morton spent years in jail for a murder he didn't commit. And another person was murdered because of that. And so this is why I hate the one witness rule. In fact, if you're the type of person who says I can't do it just on one witness could not get me beyond a reasonable doubt, you're in line with things like the Bible and Deuteronomy. It talks about that. So if you are on a jury, and you should try to get on every jury you can because it's your civic duty, then just make sure of this trick. Just tell them that you don't think one witness could get it beyond a reasonable doubt. But if it somehow did, you would find them guilty, and then stick to it. Because that's what I see as witnesses who don't stick to it. In one case, I was able to revive, in other words, give the scenario I did and show that they believe the first part, that one witness couldn't get it beyond a reasonable doubt, and not the second part, that if they did, they would find them guilty. I was able to revive 17 witnesses. 3 of them made it on the jury, but only one of them stuck to their guns and said, no, it turns out it wasn't even a witness. It was a text that was vague and had nothing to do with my client. They stuck to it, and they're the reason that I didn't get a guilty in that juvenile murder trial. So anyways, that's my summary of the one witness rule. If you're like, what is Neil deGrasse Tyson talking about? He probably embellished a bit. I don't think the judge or a prosecutor would have told the details of that. And judges do voir dire in certain jurisdictions, namely the federal government, if you're accused of a federal crime. And so those of you who are wondering, why would this happen? That's why this would happen. The one witness rule is a thing, and it's literally just a rhetorical trick for the prosecutor to get jurors that have a lower standard for beyond a reasonable doubt, which is the reason that we wrongfully convict people. Thank you for listening this time. Please, again, so many of you liked, subscribed. If you like this, please subscribe and do all that stuff. Share it, whatever you got to do. Again, if nobody ever does, and I think I'm at 3,500 subscribers now. That's more than I ever thought. I can't imagine an audience of 3,500 people. Oh man, that'd be terrifying. But instead, it's just on this camera. And so I appreciate you, the viewer. And if you have any questions, put it in the comments. I try to answer as many as possible. And most importantly, you have yourself a great day.